Okay. Do we have our laws? We want the Civil Procedure Act, we want the rules, okay, the Government Proceedings Act. This question is known as civil. It is a procedure proceeding. First listen until when I say that we are starting from here. Okay? What we deal with civil, we start with, where do we start from? In civil. It is a procedure. Okay? It is a procedure. The first thing we have in civil is conduct the client interview. Okay? And when you are conducting a client interview, we consider the provisions of Order 7 Rule 1. Okay? And other circumstances surrounding the occurrence of the events. Okay? Now, after you have conducted the client interview, then you will proceed and go for what we call formalization of instructions. Okay? After you have formalized instructions, the next step will be institution of a suit. So when you are instituting a suit, ask yourself, what are the different modes of instituting a suit? The presumption is you all appreciate it in details. Okay? Then after you've instituted a suit, the next step will be, after instituting, will be exchange of pleadings. That's called service of summons. Okay? You look at the types of pleadings that are exchanged. Once I serve you with the claim, what documents accompany that claim? Okay? We have the summons, annexed as summary of evidence. So, once I serve you with a plate with the summons are directing you to do something which is known as filing a defense. Then you go to what we call defenses. Ask yourself, once I start with a claim, which type of defense are you most likely to file? Okay, that means you will file what we call a defense with a counterclaim, a defense with a sort of a sham defense, a defense, a technical defense, or a conditional defense. Okay, you can file any of those defenses. So we presume that you have filed any of the above defenses. What is required of me? I will file what we call a reply. Once I file a reply, the presumption is the pleadings have come to an end. Once pleadings have come to an end, what is the next step in the procedure? Going for summons for directions. Ask yourself, what amounts to summons for directions? Who has the obligation to extract summons for directions, and at what time? Within how many days? Within 28 days after the last reply or rejoinder there, and it is supposed to be extracted by the plaintiff. What is the impact of not extracting summons for directions? The matter will abate. Okay, so we presume you are intending to extract summons. So you ask yourself, what are some of the contents of summons for directions? Okay, we have temporary injunctions, interim orders, okay, consolidation, test suits, okay, disclosure, interrogatories and inspections. All those are after you are done with that. Okay, summons for directions have taken place. What is the next step? Going for joint scheduling conference. Okay, once you go for joint scheduling conference, you come up with a document known as a joint scheduling memorandum. So ask yourself, what are the contents of a joint scheduling memorandum? With the presumption is we know agreed facts, disagreed facts, issues of determination, okay, etc. Then after that, you have issues you have agreed upon. What is the next step? Setting the suit down for hearing. So you fix a matter for hearing. Okay. Once you go for hearing, what do we do with you? Okay. That means we are going to adduce evidence. So under adducing evidence, that's where we're going to look at examination, how to deal with the different witnesses in civil. So what types of evidence do we have in civil? We have two types. We have affidavit evidence and witness statement. So you ask yourself, what type of evidence am I proceeding with? If you are proceeding by way of affidavit evidence, do you know the contents of that type of evidence? How do you present affidavit? Okay? How do you tender in that affidavit? If you are proceeding by way of witness statements, do you know the contents of a witness statement? How does it look like? Why is it that the witness statement is not commissioned? Because you take oath. Okay? So at that point, you presume you know everything. So at that point, when the matter has been instituted, you have numerous remedies. Okay? What happens if the plaintiff dies when you are within that time of adducing evidence? What happens to the civil suit? Does it abate or it is stayed? Okay? Does it abate or it stays? Okay? The matter doesn't abate, it is stayed until appointment of a legal representative. Okay? So we presume that the legal representative has been appointed, the matter is now ready to proceed. We shall adduce evidence, make submissions, and then court will make judgment or a ruling, whatever the case may be. So the question is, do you know the contents of a judgment or a ruling? Listen. What are the contents of a judgment? Okay. Remember the I told you to go with the judgment and the ruling? You remember that I? So now, what does that mean? Once court pronounces itself on a particular judgment, so ask yourself, what are the different types of judgments we have? We have a default judgment, okay? We have expanded judgment, we have ordinary judgments, judgment on admission, okay? So, what is the effect of a judgment on admission? Okay, so once judgment has been under consent judgment, once judgment has been passed, regardless of the type of judgment, it is binding until it is set aside or varied. So ask yourself, do you know how we set aside a judgment or not? Okay, how do we set aside a judgment? Okay, we have setting aside under order what you what and do what. You differentiate, okay, or you can explain. Okay, you get it. So when you at that point, if judgment is not set aside, or is not valid, it is a valid judgment. Due to the fact that it is a valid judgment, the successful party has a right to enjoy the proceeds of. How do we enjoy the proceeds of a judgment? By that's our class. Okay, you see how we've been moving. It is a procedure. Okay, you start your institute as soon you extend limits, you clear everything until you get judgment. So when you get judgment like this, you the successful party, you have a right to enjoy that judgment. So how do you enjoy that judgment? It is by way of execution. So today we are going to do execution. Okay, just ebaddewo omwami kubazzaayoko mu first term na temuze musoma up to that point so that we are on the same stage. Okay, so that you don't miss a step. Okay, this is the procedure for students. So today we are going to deal with execution. Okay, so when you get into execution, okay, and yes, how many types of parties do you know? How many types of parties to a suit do you know? Yes. One. Types of parties to a suit. Okay. We have artificial parties and then natural. Artificial parties we have a company. So that means assume that judgment is against the company. You don't have to execute against the company. Another artificial, we have a partnership. Assume judgment is against, and you read corporate and commercial also. Those things are under the partnership act. Okay, so assume judgment is against a partnership. How would you execute against a partnership? Another artificial party, local government. Assume judgment is against the local government. That means you go for execution against the local. Then another one, we have government. Assume judgment is against the government. How do you execute against government? Then you go to natural persons. Assume judgment is against a natural person like her. How do you proceed to execute against? Okay? Are we together? So your workshop is basically going to rotate around that. What property is subject for execution? Property that belongs to the judgment. So you should be able to tell what property belongs to the judgment later on. So under such circumstances, what if I have property which does not belong to me, and she tries to execute against that property? That it becomes this type of execution, wrongful execution. So you make an application for setting aside wrongful execution. Okay? You're not going to get them all up. Don't worry. Okay? So let me get okay? So let us presume, okay, that you see that I have a judgment, you want to execute, you know the appropriate party. So what you should know, the nature of the party you are executing against determines more than the procedure. Okay? And what you're going to execute against. The type of party, the nature of party you have determines the mode of execution and the procedure. How? And the law to use actual. If you are executing against the government, there are certain modes of execution that don't operate on government. Arrest and so arrest government. The definition of a government is a government for the people by the so going to arrest everyone. It is impossible. Okay. Can you attach vehicles for the government? That is public property. That means government has no property. Yes. So how are you going to proceed? Okay. So you should be able to appreciate all such things. Okay. If you are proceeding against me, a natural person, how can you enforce? Okay. The property this person has also determines what if the property Aisha has are agricultural producers. Okay. She has a banana plantation, but it's just at its initial stages, and you want to execute against that. So what is going to be the way? The way out. Okay. So basically the workshop is the good one. What I'm sure answer for the week, you are either challenging an execution which has not yet taken place or which has already taken place. So that means you have to understand those two remedies. You have what you call wrongful execution, where execution has already taken place, but the way it was done is not the way the law has provided. So the remedy will be looking for setting aside the wrongful execution. Okay? But where execution has not taken place, what remedy is available? Stay of execution pending whatever the case may be. Okay? If not, execution has not yet ended. However, okay, however, you realize that the property they are intending to attach doesn't belong to the judgment. Then what remedy would you have? You want to challenge attachment, you go for objector proceeding. So that's basically so I'm very sure, counsel for the week, you are relying within those three. Okay? They can't give you to make an application for execution. No. The IA is also coming from those three. You shall choose. You shall come back from dismissal or termination. Just a warm up. Okay? Dismiss. Was he dismissed or he was terminated? It was unlawful termination or unfair. Why not unlawful? Okay, let's get back of now. Okay, so let's get the law. Okay, let's get the law. Let's get the Civil Procedure Act and the rules. Okay. So when we are dealing with the execution, we are going to first ask ourselves the following question. Okay. What is execution? I think that we should believe in the okay. Then two, who has the right to execute? Who has the right to execute? Then three, what we execute? Who has the right to execute? Then what we execute? Then four, what property is subject to execution? Then another one, how do we apply the execution? Then what remedies are available in the process of execution? What remedies are available in the process of execution? Under the remedies, we are going to look at objector proceedings. Yes, what remedies are available? Okay, we are going to look at objector proceedings. Then we shall look at stay of execution. Stay of execution. And then setting aside wrongful execution. Okay. And then let's also list the types of modes of execution. Modes of execution. We have one, arrest and attachment. So now differentiate between arrest and attachment before judgment. This is arrest and attachment after judgment. Okay. Then we have sale by public auction. Sale by public auction. Okay. Then, okay. Then we have what some people call it garnishee, others call it attachment of debt. Then also have attachment. It's so when you add attachment only. Okay. What else? We have receivership. etc. etc. Okay. Now, put a note there. I know we shall repeat, but it's prudent. You understand it. Eh? There are two types of stay. Someone was asking always that question. Okay, give us two circumstances under which one can stay execution. Okay, there are two types. One, staying of execution pending civil suit between the judgment debtor and the creditor. You get it? She sold her. Okay, she won a case against her. You don't execute, but she says, you know what? I also have a case against her, which is pending judgment, and she has high chances of winning the case. Okay, so that means if she wins, she also has to execute. So you will to execute instead of. You get it? Okay. Then we have also what we call. Okay, we have stay of execution pending a civil suit between a judgment date and judgment credit. Okay. Then another one, staying execution upon application of a judgment date. Okay. Okay. So, should we now start? The second one said that staying of execution upon application of the judgment data. So now let's get our notes. Let's get the Civil Procedure Act. Universe asks, what happened about? Have you tried the Civil Procedure Act in your eyes? Yes. Now let's ask. The Civil Procedure Act. You've cited it and another applicant. Let's go on. Why are you guys now? For your colleague. Okay? For your colleague, I want this close. Okay? Okay? So let's go on. Okay? So let's get the Civil Procedure Act. I've already said this. Whenever you are reading any act, first open there, applicability. Where does that apply? Okay? So that's the law we're going to read first. Okay? Let's read section 1 of the Civil Procedure Act. It says, okay? It says this, okay? The act shall extend to proceedings in the High Court and the Magistrate Courts. What does that mean? Okay? This act doesn't apply to Court of Appeal and the Supreme Court. Okay? So, people power. Okay? So now let's go to section 2. Okay? So remember, what do we execute? What do we execute in the first place? Okay? So, by the time we end with the provisions we are going to read, the questions we've listed will be okay. Not so? So, let's go to section 2. Section 2, paragraph J. Now hold on. Let's start with I. Paragraph I. Paragraph I. We are just reading the laws in color. Okay. Okay, let's start with section 38. Let's start with 38. Because the challenge is 38 has words that are in the definition section. That's why I wanted to start with the judgment. We go to judgment later, we go to decree, we go to orders. Okay? But let's start with 38. It says execution. Okay? The provisions of this act relating to execution of decrees shall, so far as they are applicable, be deemed to apply to execution of orders. Underline the word execution of orders. Okay? So what does that mean? We execute orders. But from an order, what do we get? Mpola, we shall go. Okay? Okay? Mpola. Okay? Okay? So after that, because it says execution of.
I beg your pardon. Which section 38 of what?
Section 28.
28. Okay.
Okay. It is section 28. Okay. 28. Okay. 28. Okay. So from that section, there is the word execution of. So what is an order? Okay. What is an order? Then we go back to section 2. Section 2, the Civil Procedure Act. Okay. 2(o) defines an order to mean. Order means formal expression of any decision of a civil court in which is not a decree and shall include a rule list. Okay? A formal expression of any decision. Okay? So, court expresses its decision in form of orders. That's why judgment has orders. Orders are part of the judgment. Okay? You get it? Because when you go ahead and also read the definition of a judgment, okay? Judgment means a statement given by the judge on grounds of a decree or order. You get it? So that means in a judgment, we get orders. Okay? So we presume you have a judgment which has orders. You have proceedings. We say we have got the place in place for an order of backup possession. Okay? And a declaration that those are orders. That's why when we are writing an order, we say it is hereby ordered and decreed. What? You give orders, so from that order, you have to get what was decreed, which is a decree. Okay? So now, what is a decree? Section 2 still. Section 2C defines a decree. Okay? 2C, decree means a formal expression of an adjudication which, as so far regards to the court expressing it, conclusively determines the rights of parties with regard to any of the matters in controversy in the suit, and may be either primarily or final. It shall be deemed to include the rejection of a plaint or writ and shall, with the determination of any question with section 34 or 92, but shall not include adjudication from which an appeal lies or an appeal from an order. Okay, we were just interested in the first part. Okay, a decree basically gives you a right, it determines the matter conclusively. Okay, because if we say it is hereby ordered and decreed that the plaintiff is the lawful owner of land comprised in this, that part ordered and decreed, it is giving you a right to enter upon that. Okay, it is determining the matter conclusively. Okay, so once you get that order, ask yourself, what are you going to do with the order? Okay, are we together? So the presumption is you have a judgment, the judgment has orders, that God has ordered that you are the rightful owner of that. Once you sit with that order, it will never help you. You have to put it into. Now that is what it's called. Okay? How do this? Okay? Now let's go on. Okay? Yes? Are you okay? We go back to our section 28 now. Okay? Let's read section 29. Okay? So now, when you look at the law relating to execution, okay? The law relating to execution, okay? Where do we apply to execution? Before, we had what we call the EMA, okay? The execution division, but it was phased out in 2019, okay? But after phasing it out, based on section 29, all files were sent back to the original court. Okay? So section 29. It says the expression court which passed a decree or words that effect shall in relation to execution of decrees, unless there is anything repugnant in the subject or contest, be deemed to include a where the decree to be executed has been passed in exercise of the appellate jurisdictions, the court of first instance. You get it? Now, I will realize that now not as very good on appeal. Okay? The face of it looks simple, but it is tricky. You will end up always. They tell you that Rashid had a matter against James.
So you are far.
Rashid won the matter. The High Court of Uganda had. However, James was agreed. He agreed to the court of appeal. Okay. After appealing, judgment was entered against him. Rashid is before you. Proceed. You get the problem. Okay?
Rashid, you are far from the microphone.
Okay? That means Rashid is a successful party. So he has a right to enjoy. But this is a judgment from court of. So where do you apply? So you go back to the court of first. So I apply to the court that passed there. Because on the face of it says court that passed there, the decree. It has been passed by the court of law. You have paper. Where the matter originates? No. Go back. That's the meaning of this provision. Okay. Then another one. Where the court of first instance has ceased to exist or to have jurisdictions execute it, the court which if the suit in which the decree was passed were instituted at the time of making the application for the execution of the decree would have jurisdiction to such. Now, initially, we had the execution division, where the High Court or the Magistrate Court passed the decision. It could still have jurisdiction. So that means the matter would be at the execution division. Okay? If not that, what this means, we have courts that have been phased out. Okay? Then maybe we say we had the High Court here or the Magistrate Court here. By the time you go back, that court has phased out. So where do you go? Okay? So you look for the court that has jurisdictions within that area. Okay? So that means you have to be able to understand what we call the High Court circuit, okay, and then the magisterial area instruments. Okay? Then Section 30, court by which decree may be executed. A decree may be executed either by the court which passed it or by the court which it is sent for execution. You enter the general is court that passed the decree deals with execution. Give us 4 exceptions to that rule. 4 exceptions to that rule. Now start asking. Okay? They can tell you that counsel, the general proceed and give us the exceptions to that rule. Okay? So now this section brings in the exceptions to that rule, because it says it may be passed by the court which passed the decree or by the court to which where it is sent. Okay? That means I can tell the matter, I send the decree for execution in another part. Under what circumstances? Okay? We shall see. The law provides. But one, where the judgment says that has no property jurisdiction in that court. Okay? You realize that Kakai, all these properties in India, you sold him in Kampala. So in Kampala, you take the carpet of all this, which is not even his, it belongs to the hostel where he's residing. So literally, he has nothing. But remember, you can't just take your head to India. So you make an application for transfer of the degree. Okay? Yes, sir.
Let me give you a scenario where this is one rules in favor of the party in a land pattern. So the judge needs data apply for a fresh suit in, let's say, the magistrate's court. Magistrate's court rules it to be best in the country. And then the same person applies to that person. Then the same so the execution which court to go to?
Court of first instance.
But then LC1
now it depends. Okay, first and foremost, what was the type of land? Was it customary? Or if it is customary, what you do, you just get an order of the High Court. Okay, you just take it to police. You just do what we call enforcement, but not execution. Okay. So that's what most of the people do in practice. Where the execution can't work, we don't die. to go for enforcement. Police is there to do enforcement. I just get the order, I write land protection needs, I take to Naguru, I copy to the LOC, then they will do enforcement. Simple as that. Okay. So now, okay. So another circumstance where the property within this jurisdiction is not sufficient to get out of the text. You intending if judgment is 4 billion, the property she's serving within Kampala is of 500 million shillings. But she has other properties in Busheni. So you make an application that this decree should be executed from where? Busheni. Okay. Where the property within the jurisdictions is insufficient, okay, to settle the debts. Okay. Then the circumstances you are looking for where a decree can be transferred are all mentioned under section 31. Okay. Section 31. Section 31 says that the court which passed the decree may, on application of the decree holder, send it for execution to another court. When you read this provision, it has a word, a decree holder. Who is a decree holder? Okay, let's go to the interpretation section. Section 2D defines decree holder. Okay. It says decree holder means any person in whose favor a decree has been passed or an order capable of execution has been made and includes the assignee of such a decree or order. Okay. If judgment is given in my favor, I become a decree holder. We have circumstances where we have dates, someone is demanding me. I can assign this decree to someone else. Once I assign this person, remember now I have judgment against Anita, it's for 50 million shillings. So you demanded me 50. Let me give you this order, you execute. Once I endorse that I've given him, he becomes a decree holder, so he can also apply for execution. Okay? How do you? Yes? Enforcement, okay, is done by different authorities. Okay? Execution is done by the decree. Okay? Okay? So we go on. So now, then the first one, if the person against whom the decree is passed actually and voluntarily resides or carries on business or personally works for gain within the local limits of the jurisdictions of that other court. Now when you read them, gain your normal sanity. Have a matter in a way. I applied for execution, but this fool shifted to Hoima. Now I'm going to make an application. I transfer these people. I get him from Hoima. Why? Once I get judgment against you, when you are in Kampala, and you voluntarily change your location, because the mode of application I applied for is arrest. Okay? But the guy disappeared, so I can't arrest him. So I should apply to Hoima, Chief Magistrate's Court. They give me an order from there. Okay? Excuse me, okay, so now you get it. Then another one, if that person has no property within the local limits of that court. Okay. Then another one, if the decree directs sale or delivery of immovable property, which is not within the jurisdiction of that court. You are saying, let us sell this house, but the house is in Masaka. Judgment has been given in Kampala. So the decree is directing sale. Is land movable property? It can't come. So you go where the land is. Okay. Then, if the court which has passed the decree considers for any other reason which it shall record in writing that the decree should be executed by the other court. Okay. That's what we call discretionary inherent powers. That's why in that application, people always say that any other as court may deem, okay, any justifiable reason as court may deem it. Okay. So now, okay, once, okay, you have those circumstances, okay, and you make the application, and the decree has been transferred. Where it is transferred, that court has exactly the same powers as the court that passed the judgment. Okay? So now, we've seen the who, okay? Then, when you look at this law, it does not tell us how and when we apply for execution. So, let's start with the way. Okay? Let's look at section 35. Within what time can you apply for execution? Execution barred in certain cases. Okay? Execution barred in certain cases. Section 35 says that okay, it says that where an application to execute a decree, not being a decree, section 35, okay, of the Civil Procedure Act, okay, where an application to execute a decree, not being a decree, granting an injunction has been made, no order for execution of a decree shall be made upon a fresh application presented after the expiration of 12 years from the date of the decree sought to be executed. Okay, so they can keep and time will be executed. Okay, so once 12 years expire, you cease to have the power. Okay. Yes. You are in execution. You're not bad. Okay. Yes. Okay. Then, where a decree or any subsequent order directs any payment of money or delivery of any property to be made at a certain date or at recurring periods, the date of which a default in making the payment or delivery in respect of which the applicant execute the decree. There are decrees we get when they have that pay within. So the time they mention, once it expires, that means we are not vigilant. Okay? If you demand that, you have to demand the salaries. I won't be able to because it says that. Never worry to see now. You get that different story. Okay? Yes. Okay? So now, we want to see. We say the type. Now, one apply and apply. We'll see where we apply. What that pass there. Now we want to see who applies and how. Okay, who applies and how. Okay, that's take us to section 38. Okay, section 38.
Section 38. Powers of Section 38.
Okay.
Powers of court to enforce execution, subject to such conditions and limitations as may be prescribed.
So now, okay, so we go on. So we want to see who and apply. Okay, we shall see how we do apply for that. Okay. Okay, we go on.
Section 38.
Section 38.
Powers of court to enforce execution,
Yes.
subject to such conditions and limitations
Okay.
as may be
You see,
prescribed.
subject to such conditions and limitations.
Theory.
Okay. That's the good. Okay. Yes. Okay. Let's get back. Okay.
Section 38 of the Civil Procedure Act powers of court to enforce execution.
We are reading only a break indeed for reasons, eh?
Subject to such conditions and limitations.
Stop there. Subject to such conditions and underline the word limitation. That's why we first read the time. So once the client is before you and realize that the client is out of time, that means the law of limitation has operated on your client. So under such circumstances, court may decline your application. So you have to first cure the issue of limitation. I'll proceed.
As may be prescribed, the court may, on the application of the decree holder.
Stop there. On application of who applies for execution?
A decree holder.
We know who is a decree holder. Okay. Is there anyone who doesn't have a decree holder? Okay. Read section 2, paragraph D. Okay. Defines a decree holder. A person on whose favor judgment has been made. Okay. Now how we proceed?
Or the execution of the decree.
Okay. So you apply and the court may order execution of a decree. So that provision answers who applies and what we execute. We don't execute a judgment. We don't execute orders. We execute a decree. Okay, but now I know. We know what is a judgment, what is a decree, and what is an order. That's why we started from. Proceed.
Or the execution of the decree.
Okay. Read the paragraph.
Subject to such conditions and limitations as may be prescribed, the court may, on the application of the decree holder, or the execution of the decree by delivery of any property specifically decreed.
You underline the word specifically, property specifically decreed. Okay?
38.
Section 38. What does that mean? That if you want to execute against me, you should be knowing what belongs to me and what you want. So you specifically state that I want this from Rashid, so that court gives you an order that sell his house, sell his car. Once you don't specifically indicate what you want, court will not give you that order. Okay? I will proceed.
By attachment and sale.
Stop there. Okay? So now we've seen who applies, okay, and what we execute. But that law, does that section tell you how to apply? How to apply? Okay. So the section doesn't tell us how to apply. So the question is, how do we apply for execution? How do we apply for execution? Okay. How do you apply for execution? How do you apply? Yes. Okay, so where the act, let's listen, where the act does not provide for the mode, okay, the mode will be explained somewhere in the rules. So let's go to the civil procedure rules. Okay, the rules will tell you how. We shall see whether it is by notice of motion, chamber summons, late, originating summons, whatever the case may be. We shall tell. Okay. So let's go to order 22, the biggest order in the rules. Ask yourself, okay, let's go on. Let's come back. Okay. Let's go to order 22. Order 22, rule 7. Order 22, rule 7. It says, application for execution. Where a holder of a decree desires to execute it, he or she shall apply to court which passed the decree, or if the decree has been sent under the provisions hereunder, therefore contained to the court, then the court or the proper officer of the other courts. Okay? So when you look at rule 7, it is also not express. Not so? Do you have any other rule that is expressed? Yes? Let's proceed to rule 8 as well. Now, mark this. Your application has to include law applicable. Once you include wrong law, I have pass. Okay? Rule 8 says oral and written applications. So we have circumstances where the application for execution may be oral, and we have circumstances where the application may be written. So you should be able to differentiate circumstances that call for written applications and circumstances that call for oral applications. You'll get back when they call for oral applications. Why? In orals, they rarely give you this the written application in execution. They can tell you that Rashid filed this and this against Daniel for recovery of money under civil procedure rules order 36. Okay? Judgment has been given against Daniel. Daniel is within court premises. Proceed. Okay? Once if it is payment of money and the judgment data is there, that means you are full numbers. So you make an oral. So you'll get it oral, you start the Republic of Uganda. It's an application to execution. Okay, but it comes back to this. Okay, so let's get back. So it says, where a decree is for payment of money, the court may, on oral application of a decree holder at the time of passing the decree, order immediate execution of the decree by the arrest of the judgment data prior to the preparation of the warrant, if he or she is within the vicinity of courts. Okay, that's what I've told you. They will give you facts that court has just made judgment against Daniel. Daniel is still in court premises. Proceed, and you draft. So those circumstances call for an oral. They arrest this person even without the arrest warrant pending signing of the warrant. That at okay at least. Okay? You see when you are mad, but nowadays those rich guys, man, they are big headed when it comes to dates. Those days, if you are demanding to someone like you have people here that when you say okay, first see his friends, can they bring money to arrest him? Okay. How many family members have money? You count them, you say, let us go for arrest. Because lawyers will have the rule known as the deep pocket rule. Before you make any decision, ask yourself, where is money going to come from? So once you like that, okay, if I arrest Kakari, they will call the wife will call the father will call the brother, they will all come to police. Okay, they will give me money. Okay, so then let me go for arrest as a mode of execution. Okay, because this one. That's why me, if they arrest my relative, I don't go to police. I don't know, I'll come tomorrow. I know. Once you go to police like this, yeah, you tell them, okay, easily respond. Let them respond. So I keep on hardening the situation until the whole family comes out and they give me money. So me when they arrest me, I don't go. Huh? You don't go there again. Once you go there again, that end up home to it. Okay, don't risk. Okay, so we have the deep pocket rule. So now, if it is not oral, how do we proceed? Okay, excuse me. Okay, proceed. Okay, so if it is not an oral application, it will be a written application. But what is the format of this application? Is it by motion, chamber summons, or originating summons? What is the format? Okay, let's go to the next rule, council. 8 sub rule. It is order 22, rule 8 sub rule 2. Okay.
Every application for the execution of a decree shall be in writing, signed and verified by the applicant.
So first stop there. Says it shall be in writing. So where the law doesn't provide for the, it says in writing, wait, it will tell you the format. Don't rush, because some of you next in writing, they mean not so. So you wait, proceed.
Shall be in writing, signed and verified by the applicant or his or her advocate or by some other person proved to the satisfaction of the court to be acquainted with the facts of the case and shall contain in a tabular form.
So what does that mean? The application is in a tabular form. So you said the Republic of Uganda, the High Court of Uganda, Kampala City number, this and this. Okay, you said application for execution. You draw a table. Okay, you draw a table. So what do you put in that table?
It shall contain in a tabular form the following particulars.
What?
The number of the suit.
It says that judgment came from civil suit number, this and this.
The names of the parties.
Parties. Chinyingiwaswa versus Robert Sentam.
The date of the decree.
When was the decree given? The day when judgment was passed. You indicate.
Whether any appeal has been preferred from the
when
decree.
There is no appeal, you say no. Okay. Settlement, everything you will read. So that means everything here should appear in your table. Okay. So it is not by not so. Okay. So it is by way of the writing, but in a tabular form. Okay. So now, when you proceed here, it has what we call, because in your application, you have to state the mode, the preferable mode of execution. Not so. That takes us to okay. So, colleagues, it is exactly 7. Okay. So, allow me to take a break of 10 minutes will be sufficient for swallow and so, and we get back. Okay. So, but before we take leave, we have some visitors here. Okay. Who have to introduce themselves to us, and we know the people we are proceeding with. Okay. Line, kindly, we are sorry for the interruption. Okay. Okay, so by the time we went for break, we are looking at the different modes of execution. So which section provides for just know each mode has a section and a rule. Okay, each mode has a section and a rule. So let's go to section 30, section 38 of the Civil Procedure Act. Okay. Okay, it provides for the modes of execution. Okay. The first mode, 38. Okay. So the first mode is
by delivery of any property specifically decreed.
So when they say delivery, they mean delivering in court. Who has ever gone to Mengo? Look at Mengo, look at Nakawa, look at Makinde, Chief Magistrate's Court. We have some vehicles that are there. Okay? Look, sometimes you go to court, you say, pay the money where you deliver everything you want in court. I will find it there, as if they are angels as well. You bring money when the son has not yet dropped the account. Okay, you get it. So under that, you go for delivery in. So they deliver whatever you have decreed to court. That's why you see those cars there in court. But we are waiting for the stay. You sell them, but they sell to themselves. But it is okay. Okay. Then another mode.
By attachment and sale, or by sale without attachment.
So those are two modes. We have sale and attachment. You attach there and then sell. But that attachment goes for public auction. You get it? Okay? That attachment goes for public auction. When you say attachment and sale, okay? You attach someone's property and sell. But that sale, you have to advertise. That's what's called public auction. Okay? Then we have the sale only. We can sell by private treaty. Okay? Another one.
By attachment of debts.
By attachment of debts. That is also known as garnishing proceedings. We have a case with LDC. Okay? Don't know. I don't know that authority, but look for it. Okay? Where the LDC account was attached and they started using URA. Okay? This system of model, it wasn't there. Hey, but ask what happened. Okay? Then another one.
By arrest and detention in prison of any person.
Okay, that's what we call civil prison. Arrest and detention. Okay? That one basically on money. Okay? Then another one.
By appointing a receiver.
By appointing a receiver. Okay? Hey, that is the work. That is the idea that disorganized your predecessors. They are doing it. It was in corporate and commercial, but this was the answer from the Civil Procedure Act. Yes. Hey, joke with this world. Okay. Another one.
In such other manner as the nature of the relief may require.
In such other manner as the relief. So that in any such other manner, depending on the nature of property. Okay. Depending on the nature of the property. So you see, all of these modes, okay, all the modes we have been listing, they have an order. They all emanate from order 22, but they have different rules where they are, okay? I will get. But when you are reading, when you look at this, okay, the locals are here to break them down. However, when you read the rules, they tell you under what circumstances are you going for a sale, under what circumstances are you going for, you get it, so that you determine that the circumstances surrounding my case warrants execution by sale, execution by public, okay, execution by arrest, and so you can tell that after reading the rules. So let's make a test suit. Okay, let's go to the rules. Okay, let's go to the rules. We got order 22. Okay, order 22. Okay. Okay, so now let's get back. Okay, now when you look at the civil procedure rules, okay, they have these modes, but they are a bit detailed. You have to first understand the nature of the order we want to do. The nature will always be done in the mode. Okay, for example, where you have dates, you know that it's attachment of dates. Where you have agricultural produces, what mode do you? Okay, so the law has provided for everything. Even banana plantations we can attach, even maize. When it is growing, we can attach. We want money. Okay, so let's go. Okay, when you look at rule 32, okay, order 22 rule 32 provides for delivery of immovable. So you have to understand, okay? Okay, delivery of immovable property. So when you read that, it says that where a deed is for delivery of any immovable property in possession of the immovable property shall be delivered to a party to whom it has been adjudged, or to such a person as he or she may appoint to receive delivery on his or her behalf, and if necessary, by removing any person bound by the decree who refuses to vacate the property. Okay, so let's assume he has a car. He sold me that car. Okay, however, the car is in possession of this one who is the third party. So I sue her for breach of contract for any other specific part on this. Okay, because I paid her full purchase price. So I want her to specifically perform by delivering the car to me. So once I win the case, court will say it is hereby ordered and decreed that motor vehicle registration number this and this, chassis number this and this, be delivered to, okay, you see that order. So once I apply, I will enforce that very order. Okay, so in my application, I will put the mode by delivery of the such a property. Okay, so if she refuses to deliver the car to me, okay, so what does that mean? Because the order says even if it means getting her out, okay, if I find her on Kampala Road cruising, Okay, I tell her stop. Okay, you know how bailiffs operate. Come out. Okay, they tell you to sit even down. They drive the car peacefully. Okay, that's how that order can give you power. If it is a house, okay, that's why they are called Bawanyongo. They don't negotiate. They come, they say, you either get out or we hammer the house. Choose. That's the power of delivery. Okay? So bailiff has powers after getting that car order. Here. But once they do wrongful execution, the way they disappear. Yeah. Okay. Yes. Okay. That's why I've talked about land. Okay. Yes. Okay. Because house is land. When you go back to land law, what is land? Anything attached, degree of attachment. Okay. We go on. Okay. No, we still have other modes here. But when you look at attachment, attachment has different things when you read the rules. Eh? For example, that one would say attachment of movable property. When you proceed, we have. Okay. Then we have attachment of agricultural produces, attachment of a decree. Okay. So depending on what you are having. So the rules will be clear. They can give, okay, one attachment of partnership against the partnership. So this is a case to case basis. Okay. So I think that the modes we shall read the chapter. Don't so? So now after, yes? Yes. Okay. So now, after you've looked, the presumption is you have indicated, okay? You have indicated the mode you want, okay? What else you should indicate? Property you want, but the rule is property should be belonging to the judgment data. So what does that mean? We have that due diligence that is supposed to be done before. Okay. So which law provides for property? Okay. Yes. Okay. So the general is you attach property that belongs to the judgment. So what happens if you attach property that does not belong to the judgment? Data. Okay. Let's look at 43. Rule 43 says attachment of debts, shares, and any other property not in possession of a judgment. Mark this. We have different things. We have not in possession and not belonging. You get that? I may not be in possession, but when that property is mine, okay, that is the 43, okay. But we have where the property I'm in possession, but what I am possessing doesn't belong to you. That's what we want, okay. Okay. That is known as objector. Is under order 22 rule. Right. Okay.
Rule 55.
Okay.
Claim of objection is what? 55 rule because it has some element of claiming objection. Objection proceedings are
Okay. Let's get back. Let's start with the rule 55. Let's start with rule 55. Investigation of claims and objections to attachment of attached property. Okay. Says where any claim is preferred to or any objection is made by attachment of any property attached in execution of a decree on ground that property is not liable to attachment. Okay, so what does that? Under what circumstances will property not be liable for? Where property does not belong to the judgment. Okay, I may be in possession, but when that property is not liable for attachment. Okay, so we proceed. Okay, property is not liable for attachment. The court shall proceed to investigate the claim or objection with the like power as regards examination of the claimant or objector, and in all other respects as if he or she was a party to a suit, except that no such investigation shall be made where the court considers that the claim or objection was designedly delayed. Okay? Why? Now, you should know this is what we call objector. They have a limitation under here. Okay? You have designedly delayed. Once execution has taken place, you can't go for objector. You object before an order of execution has been. You get it? Okay. You remember what happened in family. Okay? In the procedure of execution, we have where we have to advertise. Okay? Once you advertise and realize in an advert that property guys are advertising is your property, but your brother has been using your car. Okay? When you are returning that return, when you're returning that advert to court, okay, court will proceed and grant an order of execution. But make sure once you see the advert, you go here. We don't caveat. Here we make an application for objector proceedings. You get it? Okay. This is civil procedure. It has stages. We have before, during, and after. Before is when you have the judgment, you are moving around. So this during is when you start applying. Okay? You apply and go to grants you. So when I apply, before an order is made, and any person comes out claiming that the property you have applied to attach is my property, it is called objector. So you make an application objecting to that attachment. Okay, so what does this mean? You are not supposed to delay. Okay, so that means the application is supposed to be made before an order is made. You get it? Huh? Is it home? Okay. So, what I mean that the is property which is liable for execution is property that belongs to the judgment. So, where I make an application with an intention to attach the car she's driving, because I've seen her on a daily basis driving this car, and I have judgment against her, not knowing that she borrowed the car from the brother. Okay? So because me, I reasonably believe that it is her car. Okay? You know how they can think cars say, I'm proud Mengonian. Say, oh, she's even my old from. So that means, okay, signs and symptoms that the guy has. So me, what I do, once I file a suit against her, I win. I have to enjoy it. So as a mother, I say, Akamoto car. You get it? Okay? Let's refer to section 44 of the Civil Procedure Act. Okay. No, we are still on property, so that we would get a deep understanding. Okay? Section 44. of the Civil Procedure Act. Okay. Let's listen. It says property liable to attachment and sale in execution of a decree. Okay, it says the following property is liable for attachment and sale in execution of a decree, namely land. Okay, but everything we are mentioning should be belonging to the judgment. Land. So if you want to attach land, first go and make the search. You ascertain whether this land is really registered in the name of the judgment. Another one, houses, other buildings, goods, money, banknotes, checks, bills of exchange, promissory notes, government sureties, okay, or other sureties for money, debts, shares, incorporation, and except as hereinafter mentioned, all other sealable property, movable or immovable, belonging to the judgment. That's the rule. But we have circumstances where you can apply to attach this property when the property doesn't belong to the judgment. Okay. So how to get? Yes. When you don't know, so then this other person comes out saying that property is mine. It doesn't belong to him. Okay. But you have other properties which are not supposed to be attached. The law has went ahead to mention those properties as well. That once you see this, please don't attach. Okay? Like what? Women.
Wearing.
Okay? Then let's first read the law. Okay? Because some people say, I had a song which said, my and my. Okay? The person who claims that is his property. And then let's get back, okay? We want to cut this cake, but after that, understanding this. Hey. Okay? Let's get back. Members, we are living at age that whether we are done or not. So let's get back on board. Okay? Hey. You wait, you go for wrongful execution. Okay? We don't rest. Okay? Then they are saying that, okay? They are saying that, okay? Whether the property be held in name of the judgment debtor or by another person in trust of him or her, except that. So the exception, that means the properties we are mentioning here are not subject to attachments. One, the necessary wearings, okay, cooking vessels, beds, beddings, okay, of a judgment debtor and his wife and children. Okay, and okay, you know, many are funny. They are like, okay, so now you get it. So let us listen. So once you make an application for attachment and you attach cups, plates, spoons, hookers, that it becomes wrongful execution. Okay, are we together?
Yes.
Okay, so let's take a break. Cut this cake and people settle their mind so that you can proceed effectively. Okay, so let's get back. So, okay, let's get back. Okay, we've been looking at property which is liable for
Attachment.
Okay, so it said that the general is only property belonging to the judgment.
Yes.
And again, when you read section 44, Not all property is that is owned by the judgment debtor is liable for. So section 44 has excluded some properties from. So we don't deal with such funds, beddings,
wear clothes,
okay,
children.
ornaments, children, wives and husbands. Okay, so you can't attach someone's beautiful daughter. Okay, that is as per section 44. Okay, why? You never know. Okay, so now the presumption is you have made your application, you have included the mode, okay, and then you have went ahead. Now you know the property you want to attach. Okay, so now we want to look at the procedure step by step. That's how, still under our how. So the remedy at that point is okay, where property attached doesn't belong the judgment, then I would say it is objection proceedings. Okay, so now let's look at the process by process of execution. Process of execution. The presumption is you have your judgment, you want to apply for execution. Okay, you have your judgment, it has orders therein. So what is the procedure? Okay, what is the procedure of executing? Okay, so when you look at rule 22, order 22, rule 8, sub rule 3. Okay, order 22, rule 8, sub rule 3. We are starting to break the procedure. Okay, so when you read that rule, it says that the court to which an application is made under sub rule 2 of the rule may require the applicant to produce a certified copy of the decree. So how do you get to that point? So what does this mean? After obtaining judgment, which has orders, the first step shall be extraction of decree. Okay, but okay, once you have judgment, okay, it is order 22, rule 8, sub rule 3. Okay, it says a certified decree. So here you have judgment only. Okay, so but how exactly does it really apply? What we do, because we want to execute something as a bond. Okay, so what we do, the first step is we extract the decree. This is the first step. The first one is an application for taxation. You first tax costs, not so? No, you wait, we are going to get there. Okay? Uh-huh. No. Remember, when you have what we call the advocate client bill, the bill of costs. Okay? So you want to execute just the decretal sum and leave the costs, you go for another time. You get it? So what happens? They move together in practice because, once this person gets that I've paid the advance party, cancel go money. That other costs and delay. Now I first deal with my interest. So in practice, what lawyers do, they first apply for taxation, the bill of costs. After taxing, you get what we call the certificate of taxation. So you extract a decree, you attach it, you serve them. They agree with the decree. Okay? Then after these guys are valued, that's when you start applying. But if you are not interested in the costs, what they do after getting the judgment, okay, you do what we call extraction of a decree. Okay? But when you are extracting a decree should agree with the contents of the judgment. Me, I drafted the decree in account. I missed the full stop from the wording of the judgment. She told me it does currently called that justice is in this. Because of a full stop, he said, look at my file. Does it agree with the judgment? Because of a full stop. So when you get the judgment, first peruse the judgment, you understand the contents of the judgment. Okay? Then after that, extract your decree. But make sure the decree agrees with the judgment. The exact wording of the orders should be the exact wording in your decree. Okay? After extracting the decree, what next? You serve the decree to the adverse party. Yes? Yes? Okay? No, we say it. Okay? We have circumstances where some lawyers will disregard the costs and they don't perform taxation hearing. Okay? That's what the workshop calls for. But we have circumstances where they may give you. Okay? We have circumstances where you have to execute with your costs inclusive. So as a result of that, you first make an application for taxation, you get a hearing notice, you serve it, and you go for hearing or taxation of the bill. After taxation, they issue with what we call a certificate of taxation. So that certificate shows the exact amount of costs you are demanding. Okay? That tax, because the taxes, what happens in taxation? You draft your application, you say plain, draft the plain 500,000 shillings. So when you go to court, they open the rules, the advocate's remuneration rules. They say drafting the plain is 40,000. Why did you charge 200,000? So they deduct. No, you pay that money indirectly. So at the end of the day, you can remain with 1 million like this. That's why if you get clients, you cover them very well because you know at the end of the day they also discipline you. Okay? Yeah. So after taxation, you have what we call a tax certificate. Okay? Yes? Costs the advocate. Yes. Costs are for the advocate. That's why it's called advocate bill of costs. Okay? And that's the benefit of being a lawyer. Okay. So now, after you've done the taxation, that's when you draft down a duty. Then after drafting the duty, you serve. Okay. You get it. Extracting, it's the same. Okay. You get it now. Okay. So after you've extracted the decree, you have to serve the decree to the adverse. But why? For confirmation. For confirmation. Some lawyers are stubborn. I can increase the amount of money. The judgment says 2 million. Here I put 2.6 in a decree. And what is in the decree? What I will take. So once you serve the adverse party, they should get their copy of the judgment. They read the judgment and your decree to ascertain whether the decree agrees with the judgment. Okay? Where the decree agrees with the judgment, they will sign, okay, on the decree to show that the decree agrees with the judgment. Okay? Then after that, you take the decree for certification, because the section talks about certified copies. Okay? You take your decree for certifying. Then after certifying the decree, then you draft your application, the tabular form. Okay?
Execution.
Then you draft the application for execution. Okay? So on that application, you attach the certified decree, you attach a copy of the judgment. Okay? Well. Then after, okay? So, okay, you draft an application for execution. Yes. Yes. And then draft your application. Okay. After drafting the application, then for execution. Okay. Then you pay the necessary court fees and file. Okay. You attach the judgment, you attach the decree. Okay. And sometimes you not sometimes you also attach the NTC, the notice to show cause. Okay. You attach the NTC, notice to show cause why execution should not issue. So after filing, okay, court will proceed, okay, and sign the notice to show cause. After signing the notice to show cause, it will be served to the adverse parties. Okay, the notice to show cause will be served to the adverse party. He or she to enter appearance to give reasons why execution should not issue. Okay. Upon appearing and this party has no sufficient reasons why execution should not issue, court shall proceed and grant an order of execution. Okay. Court shall proceed and grant an order of execution. Okay. Okay, so you draft the application. Okay. After drafting the application, you pay the necessary court fees. Okay. After paying the necessary fees, you file your application. You file the application. Then after filing the application, court will sign the notice to show cause. The notice to show cause. Then after signing the notice to show cause, it will be served to the adverse parties. It will be served to the adverse parties. Okay. Then upon appearing and that adverse party has no justifiable reason why execution should not issue against him or her, court will proceed and grant an order of execution, what is known as the execution warrant. Okay? But that order is not given to the judgment president. It is given to who? The bailiff. Okay? So what does that mean? You have to notify the intended bailiff so that that warrant is given to the US Kakari. No. Hey, it's a bailiff. A certified one. Okay? Okay. So are we together? So now, mark this. That warrant will state, okay, members listen. Okay, yes, Council. Now, in your application, you attach a certificate, okay, of a belief you want. Okay? Yes, because you don't have the authority to do execution. But yes. You are just attach a copy, a certificate of that belief. Okay? Yes. You indicate it in your application. Okay? So the warrant states the time when it's supposed to be executed. Okay? They always tell you 1 to 2 weeks. They give you that time frame of 2 weeks mostly. Okay? So once it is given to you, okay? Once court has granted the warrant, okay? Emphasis should be put to the presidential directives, the eviction directives of 2020. Okay? So that means after the warrant, after the warrant has been issued, the next step is taking the warrant for enforcement, where you write to Uganda Police Headquarters. Okay? Headquarters. That's the part they don't teach in at LDC. Okay? You go to, okay? You write the application for enforcement of the warrant. Okay? That application is addressed to the big man of police, the IGP. Initially, the application was supposed to be made to Land Protection Unit, CID, but the procedure changed. You write to police headquarters, you copy to the Land Protection Unit, and then they start serving the different police stations. Then after you go for execution. Yes? Yes? Yes, that's when you write to police for enforcement. Okay? You Land Protection Unit, CID. Okay? Yes, you're farm, right? Sorry. Okay? So what this name exam understanding, you say, you put your law firm, you say, read, okay? Execution order, this and this, okay? Or a posting of warrant and warrant of execution in this, okay? You address that person, you give that. We ask for on behalf of our client, Mr. So and so, who is the judgment, creditor, and civil suit number, this and this. He obtained a copy of the execution warrant attached here too. But they attach the original warrant, not the photocopy. Okay? Okay? We have the original attached, but sometimes they give us like 4 copies now. Okay, so you attach. If you don't have one with a seal, go and certify. But the photocopy doesn't work. Okay. Okay. Then just stops where the warrant is. Okay. Then after that, it goes with national law, but they will ask for it because it is a presidential directive. Okay. You know, I don't. It's not attached here. The reason why you go for taxation, to know the exact money you want to get from this person. Yes. It is also the same way. The reason why you first go for taxation, you add the money in the judgment and the costs so that they settle it at once. You get it? Because remember, they set costs of the suit hereby, so you don't know the costs. That's why you go for taxation. It forms part of the yes.
So you need to attach that.
Okay. Yeah, you can attach it. Okay. So now the presumption is the warrant, you have executed that warrant. Once the execution is going to take place, it is supposed to be done the way the warrant is stated. Okay? So once you execute in a manner not prescribed in the warrant, that's wrongful. That means the remedy at that stage after execution is wrongful. Okay? You get it? Once the warrant has been issued and it has been enforced, and when you come out claiming you have issues, you can't object now because we object to something that has not yet taken. So now execution has taken place. What are you going to object to? Okay. So what you go for is setting aside wrongful execution. Yes, sir. Yes. I need to say it back and discuss again. So now, okay, for the interest of time and justice, I want us now to read workshop 1 and you see. Okay? Are we together? So we are going to stop at setting aside wrongful execution. Okay? So I want us to read workshop 1 and we see. Members, let's get back, okay? Yes. Mm. The law doesn't sanction illegality. That's the first thing. But where the transaction is irreversible, you proceed against the bailiff in his personal capacity. Yes, in his personal capacity. Because a bailiff is the custodian of the law, not so. He was the one who was executing. Why did he do that mistake? When you look at the court bailiff rules, they require them to use reasonable skill and care. But this guy is 6 man. Bailiff. Plus is also working in court. So now let's get our workshop. That's already for us the learning outcomes of workshop 1. You will see that all the learning outcomes now you have an ID. Okay? Let's read learning outcomes.
By the end of the module, students should be able to explain the legal principles relating to execution, determine the most appropriate mode of execution available to the successful party, effects the various modes of execution, prosecute an application for a stay of execution, stroke set aside an execution prosecute objector proceedings, recognize and deal with ethical dilemmas.
So, from the learning outcomes you've had, have they mentioned anything that we've not talked about? Ethical dilemmas. Okay. So now, let's read the facts and we see. Okay? Uh-huh.
These are the learning outcomes. These are another ones for action one.
Let's just, they are the same.
Okay. Facts.
Facts, uh-huh. Let's listen, members, okay?
Assume you are a senior legal officer at Mostico and Company Advocates, where you were recruited recently. Your first assignment is to advise the senior partner on how their client, Tugume Paul, can recover his decretal sum under a court judgment passed in High Court Civil Suit number 322 of 2020.
You see? So ask yourself, who is Tugume?
Judgment creditor.
How do you call him? How do you call him? Is a decree? How we proceed. So you see, at what stage is the matter? The matter has been concluded. So Tugume is the successful. The successful party has the right to enjoy the fruits of. So now Tugume wants to enjoy the fruits of the. Now we want to see what orders are in that judgment.
You have perused the case file. You notice that actually all the defendants were duly served with the summons as per the affidavit of service. The judgment is here too attached in Appendix 1.
So now we can read the judgment. Open at the back of the workshop. Okay. Are we there?
Yes.
Okay. Now, I want you to be very keen. Read the parties. Read the parties. Okay? Okay? Read those parties. Carefully mark this. Read the parties. Read the parties.
Tugume Paul, plaintiff, versus Walakira Moses, Ebubu Samuel, Mugisha Praise, Clever Owamani, T-stroke A Wemo Advocates, defend.
What does that mean? Trading as. So that means it is execution against. So who did the partnership act? Remember now, I told you that at the beginning, that what determines the nature of the parties. So now these guys are a partnership. So what we are looking at, there are people of partners. Let's also join judgment. So the question you have to first ask yourself, were all the defendants served? The facts told you that they were served. Based on what case? The case that talks about the service. Love that case. Very well. Okay? That talks about service on a partnership. William, Gatete. Okay, we proceed. So now, after this, understand that a partnership has no corporate personality. So what does that mean? You are going to proceed against the partnership property and then the individual property of owners. You are together now. Does a partnership has corporate personality? So who has liability in a partnership? So now partners are liable. We can sell their properties one by one until we get money. The exception to that rule is where a partner is a minor. Are we together? That is corporate now in civil. Now you're going to have execution against the local government. execution against the government, execution against the company, execution against an individual like me, all in the same workshop. This one, we proceed, Council,
Okay. Before Honorable Justice Jackson Magesi, judgment. Togo may poll the plaintiff. Okay. It's better now.
Read the orders. Order there.
What you're saying in the end, judgment is entered.
Now, let me give you a technique. You can't read the same
Yeah, you can.
So, what are the concepts of that? You have a heading, background, analysis, decision, and then the orders. You just call the orders up. Because you are interested in an order, but not the one go. So just looking at the back of the judgment, orders are there.
In the end, judgment is entered for the plaintiff in the following terms.
So these are the orders. One.
A declaration hereby issues that the defendant's actions amounted to professional negligence. Measly profits of 45 million. General damages of 100 million. Exemplary damages of 50 million.
So add that money. Okay. 190. That's what we call the decretor sum. The decretor sum. Okay. So, are we together? But now look the last order.
Costs of the suit.
Costs of the. So do you know how much costs have been awarded?
No.
So that means the first step we shall go for taxation. So we have to tax the cost so that we add the amount of the cost to this. You get it? So that we have the entire sum. Okay. Now, Council, get why I was talking about taxation in the first place. So now, your client has won this match, but the last one is also inclusive. Now go back. You don't need to do that alone. Now go back to our question. The presumption is you read the entire family. Don't read what is not necessary. Go for what is necessary. One thing again, you learn what the court taxation is. Okay. So we go back. Listen, members. Now, mark this. Whenever you are given a judgment, first look at the date when it was delivered. You get it? When was the judgment delivered? Okay? Look at the date at the end.
22nd February 22nd Feb 2022.
You get it? 22nd Feb 2020 what? When is today?
Today is 10th of March 2023.
What time has passed? Can they execute?
Yes.
Then you go back to the question. You get it?
Yes.
Because the application is subject to the law of limitations. So you first ask yourself, am I still within time? We go back.
On the 3rd of March 2022, the plaintiff's bill of costs was taxed ex parte and allowed at 30 million.
So what does that mean? Now they have saved us. We are not going for the process of taxation. You get it now. Yes. So sometimes they will give you a question where taxation was not done. When you have to include it in your procedure. So if you just go with that and the question changes like this, it will become a problem. Okay? So you should have in the two the two sides. Where taxation is done and where taxation is not
Done.
we proceed.
A certificate of taxation was duly extracted, signed, and sealed by court. However, till today, none of the defendants has made any attempt to discharge the decretor obligation. You have today learned that Walakira Moses has a plot of unregistered land described as approximately 25 decimals, located at Uchugo along Mitiana Road, and two motor vehicles, to which motor vehicle reg number UBA 168M, a Mercedes-Benz, and UBF 168M, and a Mercedes-Benz ML, which his wife drives. The official records at TRA Motor Vehicle Registry still indicate ownership as Walakira Moses and Eunice Walakira, respectively.
Now, okay, you get it. There is a challenge on one property. The car has Eunice Walakira. She doesn't belong to Walakira, him as a person. You get it. So what does that mean? The ML is not property which is subject to. Can you wait? That question will have part B, where that car has been attached. Automatically. Okay? And how we go on. So here, this paragraph she has just read, okay? It talks about property liable for. So you start marking. Is this so? This land is unregistered. You have to make due diligence to ascertain ownership. Okay? Let's go to the next paragraph.
Meanwhile, Ebubu Samuel has completed his house and is residing therein with his wife, Awan Uwera Tasha. They got married in 2014. The said house is comprised in Chagwe Block 76, Plot 17, and located at Sunday Jogo Mukono District. The land was registered on 17th April 2019 in the name of Uwera Tasha.
So is that his property?
No.
You can't attach. Open.
On the other hand, Mugisha Praise owns 20 heads of local cattle. They are being kept in Busheni at her uncle's home, Awan Mugisha Godfrey. She owns a tea garden at Chamuhunga, sitting approximately on 5 acres.
Now, where is this property belongs to one of the judgments?
Debtors.
Look, open our judgment. You read the title. You read the title of the judgment. Where is it? High Court of Uganda, where?
Kampala.
Now you come and look at the properties. Are all the properties in Kampala?
No.
The properties in Kampala, can they satisfy the decretor sum? So even before you read the questions, they have said this property is where. So what does that mean? You're going to do what called transfer of. We read about transfer, not so? Okay. You've not even read what the question requires, but I'm very sure that's what it's supposed to be. And because you read the law, now we are just applying the law, but not the. Tomorrow you're going to apply facts on the law you've not yet read. And you leave this place at around 2:30 or 3. Or we're discussing what? Okay. But however, the challenge is you don't read the law before you go. Start gambling. Okay. So let's go to the tasks.
No information.
Yes. This is what we call attachment of agricultural produces. We have tea garden is agricultural produces. Then the 10 heads of cattle. Which type of property is that? Is it movable or immovable? But it is movable, but still falls under agriculture. So we have a provision under procedure rules under Order 22. Attachment of agricultural produces. So the tea garden, how do they attack? The law is very clear. Just get a signpost, you put it at the visible place of that garden. Property attached. Okay. It is under order 22, but I'm not certain of the exact rule. Okay.
Yeah.
Okay. It is rule 41. Rule 41. Okay. Okay, we go on. Members, listen, okay?
No information is available on the property of Clever or man.
What does that mean? This fool has no property. So, are you sure? So, if he has no property, what mode? Arrest. The relative will bring it is very simple. Then tasks. Let's look at the tasks. He has no property. So arrest him. So the mode of execution is arrest and detention. You are guys.
Okay, task A.
Let's go on.
Task A. In a legal brief to the senior partner, advise him on the rights of your client in the circumstances.
So who is your client?
The senior partner.
So he has a judgment. So what right does he enjoy? A right to enjoy the fruits of. That's what a right applied for execution. Another one.
The viable modes of recovering his money from the debtors.
We have what we call attachment and sale, and then attachment of agricultural produce, and then arrest and detention. Okay, but that one's not the oral one. This guy is not in court. Yes, he's not in court. That one operates where he's in court. Okay, so we go on.
The property liable for execution processes.
I can't answer that. It is self-answered.
The property liable for
Property liable. Okay.
processes.
Section 44. Section 44. Yes.
The steps, procedures to take in pursuit of the said recovery process.
That's the process of execution. And then lastly, you draft an application for
Execution.
Okay, the tabular form.
Appendix B form 5.
Then let's look at part B. Attachment.
Attachment and sale. Attachment of a share. No, they are not.
There is no property, there is no company. Attachment and sale of houses, then you have
Attachment of agricultural produce and arrest.
Let's go to part B, comrades, okay?
Assume you now represent Eunice Kwalakida. She informs you that UPF 168M, a Mercedes-Benz ML, has been attached by a one Mupakati Edmond, the bailiff from Swift Court Bailiff.
Don't even proceed. That one brings which application is that? Objector proceedings. Okay. So first read very well. First read very well. Listen, first read. Okay.
The bailiff from Swift Court Bailiffs and Auctioneers Limited. She informs you that the said vehicle was attached by the bailiff at Kampala Parent School, Naguru, as her husband, who was driving it, was exiting the school after dropping off the children. The said bailiff then told the husband that at least the vehicle will enable him to pay off part of the decretal sum in HCCS number 322.
What does that mean? This car has not yet been sold. Okay? But where it was sold, it couldn't be So that calls for objector proceedings. Okay, we have another part. We go for wrongful execution. So that is workshop 1. Very precise, very easy, and affordable. Yes.
The one that is not so with that's
Council Shidi.
So, members, okay. Members, let's get back. Let's read the tasks. Okay? Members, let's read the tasks. We call it a day. Okay? Cancel read the tasks of part B.
Council Shidi, I have a question.
Okay, hold on, Cancel.
Okay, the questions of task B.
Uh-huh.
Advise your client on the remedies in the circumstances.
So, who is your client? So, what remedy? So, the remedy is an application for objector proceedings. How do we apply? By notes of motion. By notes of motion. Okay. Okay. Yeah, let's first read as well, Maria. Then another one.
The procedures you take in effecting them.
Okay. That one is clear. Procedure: you draft the application, you pay the necessary fees, you file, you serve, you go for hearing, like that. Okay. Then court does investigations, like that. Once you file, court will do investigation. You already that law together. Okay. Yes.
Draft the necessary documents you need to use in court.
That's the notes of motion.
What are the ethical considerations?
Workshop 1. Workshop 2. Sorry, yes. This one is under which section?
No, it's what you are somehow guiding us. If I remember.
Members, listen. Okay. Members, wait. Okay. Hold on.
That one has another in respect of Mopakas Edmond. Yeah, they mentioned him. His over his uncle.
The belief, not so.
Because I saw that name.
Okay. Members, listen. Okay. We have, before you go to workshop 2, there is task 4, which is supposed to be held by group 4. Okay. I want to harmonize on that. Who is Mupakasi Edmond? The belief. Okay. So listen carefully. Okay. So what happens on the part of Eunice? You're going to discuss two remedies. You're going to discuss objector proceedings and then discuss wrongful execution. When they say wrongful execution, remember wrongful execution to proceed against the bailiff. So they want you to defend the bailiff. Get it now? Yes. Yes. Hey.
That's what someone is saying.
So, let me guys wish you the best.
Yeah.
Thank you for being persistent. Thank you for maintaining time. We appreciate you. May God bless you. And may God bless Aisha. So, members, the class has come to an end.